Welcome. My name is Janet Levitt. I'm the Dean of the University of Tulsa College of Law, and I want to welcome familiar faces and some new faces to the College of Law. One of my former professors sitting right there, so gotta be good. But anyway, I'm just here to. I am just here, and I apologize for being a couple minutes late. It's our Oklahoma Bar Association convention, so I just ran from downtown. But it is really a true pleasure to be hosting this conference. Before I became dean, I dabbled in the world of norms as they apply in the international commercial realm, and I'm very excited and hope to be sitting in as much of this conference as possible. I will say that I sit in a lot of meetings as dean, and this week we had one of the more entertaining exchanges in trying to figure out if we are going to be live tweeting this on what the hashtags should be. So here were just a couple of the recommendations. Hashtag truthful negative gossip, hashtag public shaming, hashtag adult entertainment at TU, or hashtag baseball empires. I won't tell you which one we decided on. Actually, I'm not sure if we actually made a decision, but we had a lot of fun. And it's really my job to welcome you, but to also welcome Bob Spoo to the podium. I was trying to think on the way driving over here, what kind of social norms has Bob infused into the law school community since he's arrived 5 years ago? I guess the one is he has, I don't know if this is a social norm, but he has a habit of coming by my office every day at about 5 p.m. When I'm actually might have the time to sort of close things up or start doing email and catching up on the things, so maybe I can get home at a reasonable time. And Bob comes by almost every day, just about that time, with a cup of coffee, and we actually, it's a high point of my day because he's such an interesting and fascinating person, and he's such an asset to the College of Law. I think all of you, I'm not going to read Bob's bio, but he came back to the University of Tulsa College of Law from his previous life as a James Joyce Scholar and English professor at the University of Tulsa College of Law. He actually enrolled as a student here while he was a professor, and quickly got the highest grade in every class that he took, and I think our students were having a riot because he was knocking it out of the ballpark, and so he transferred to Yale, and had really a great career there, and what I just love about Bob's career is he's such an intellectual and lives in an idea world, but he also, because of his practice background in IP and copyright and his own experiences, which touch so closely to his passions of James Joyce and these turn-of-the-century authors, really brings this unique combination of intellectual up here and also the practical experience up here. And I'm currently having meetings, one-on-one meetings with all of our 1L students, which we don't have that many, so I can do. We're a small law school, about 100 students in a class, and you should hear his contract students talk about his class and how he's really inspired a lot of students through that class, which we know is not always the favorite first-year class. So I'm going to turn the podium over to Bob Spoo.
Thank you so much, Dean Levitt, and that's the high point of the conference, and thank you all for coming. No, there's much more to come, and we're all looking forward. I want to welcome you all. I want to welcome students, faculty, local attorneys, and friends and members of the community to our conference, our fall conference, becoming almost an annual fall conference based on Chapman Trust funds. I'm the Chapman professor which really gives me some opportunity to bring in some interesting events and folks. And this is one of the high points of my year. So I'd like to thank the Chapman Trust and especially Sharon Bell and Greg Gray, who make this possible every year. I am a Chapman Professor. I'm also Associate Dean for Faculty Development here at the College of Law. It's been a great pleasure being here the last 5-6 years. I gravitated back to the University of Tulsa on the law side in significant part because I saw wonderful things happening here, as I had when I was a student, and with Janet Levitz, then new leadership, I really saw wonderful things happening, and they have happened. Our conference is short-titled Order with or Without Law. And that title suggests a number of interesting questions, and all of those questions put law in the witness box, or under the microscope, you could say, and asks the question, among other questions, is law always and everywhere necessary for there to be order in societies, industries, communities, groups? We'll be talking a lot about what we call informal norms, sometimes social norms, norms-based rules. There are a whole bunch of ways of saying it, but in each case it has to do with something that does not involve, at least completely, the formal rules that we recognize as laws, statutory, judicial, or otherwise. The idea of informal norms has come to the fore in the last recent decades of legal scholarship. You could say that in some ways it's a subject that has always been there, something like the purloined letter hidden away in plain sight. Anyone might have guessed, except perhaps law professors and lawyers, that something besides formal law, formal rules, order and govern so much of our private lives and social and professional interaction, from the etiquette of dinner parties to the jockeying for parking space that many of us engage in every day, from the rules concerning copying and crediting among stand-up comics, to the rules that neighbors observe for maintaining a common boundary fence. Lawyers and law professors tend to be, we were talking about this earlier in our private group warm-up, tend to be, in one way or another, legal centralists, as we've called it. For them, law plays a command role in society, as Thomas Hobbes and other theorists have taught for centuries. Without it, life is nasty, short, and brutish, not necessarily that order, the Hobbesian formula, and chaotic and anarchic in the literal etymological sense. Today, however, a growing number of legal and sociological thinkers, many of whom central in that group are here today and tomorrow, believe otherwise. They are alert to the absence, not the presence, of formal law in creating and maintaining order. These people, and as I say, we have great ones among us today, are all more or less what we might call what have been called legal peripheralists. They believe that law does not always or necessarily monopolize the role of ordering and governing in our lives. If you attend all the events in the next 2 days, you'll hear about the following. I won't say much, I'll just give a taste. Membership associations like international soccer associations and the role of neutral third-party adjudicators like soccer referees and baseball umpires in defining these associations. You'll hear about why Hollywood and television writers receive public screen credit, while the individual creators of advertising ideas and concepts remain mostly anonymous outside of their Madison Avenue firms. You'll hear about informal rules that govern the copying and crediting of chefs' recipes in the culinary world. You'll hear about what online pornography can, and the rules and roles of online digital distributors can tell us about the gaps that exist in intellectual property law. You'll hear about the social norms of asking and telling. In fact, you're about to hear that. Something we've all been doing before we can remember, as for example, when we're asked on the street for and give the time of day. Who'd have thought that we were merchants of time who give away our services for free? You'll also hear tomorrow, the panel I'll be on, about 19th and 20th century American publishers, how they distributed their products to mass audiences, and how they employed a certain informal trade norms to fill a copyright gap that existed for foreign authors in the United States, in effect creating or recreating copyright law out of the void of the public. So we'll be exploring how norms, folkways, associations, collusions, and cartels, among other things, have filled what Cal Rossial and Chris Sprigman, who are here today, call law's negative spaces, the gaps, nooks, and crannies of law's lacks, failure, or indifference. Norms make those spaces positive spaces for research and scholarship, and we welcome you today to that positive space. Thank you. Let me turn it over to my colleague, Professor Stephen Galoob.
Hello. I have the pleasure of introducing a really distinguished panel of legal scholars of norms, and I've asked them all a single question to help orient them to you. So I'll introduce them one by one, or I guess before they come up, and then I'll reveal to you the answer that they gave to this question. So are we going with you first, Chris? Yeah, so the first speaker up is Christopher Buccafusco, and he is the Associate Professor of Law and Co-Director of the Center for Empirical Studies of Intellectual Property at the Chicago Kent College of Law. His research ranges widely across the fields of intellectual property law, law and economics, and specifically the subset of that discipline that's concerned with the effects of legal and social norms on psychology and behavior and legal history. His talk today is entitled Informal Norms, Moral Intuitions, and Creativity, and the common question is, the social norm that Professor Buccafusco most often breaks is, anybody want to guess?
I'm not doing it today.
Yeah, the norm against men wearing brightly colored trousers and shoes.
I felt today was...
We are all the worse off for Professor Buccafusco's compliance with the norm. I
apologize. Wonderful. Thank you, Stephen. I appreciate that very much. And as the first speaker, I get to be the first person to thank Bob for setting up this really terrific conference, and also to Barbette and Gina, who've done a great job of organizing everything. This has been incredibly smooth and really terrific, and a lot of fun. And so I'm really grateful to be here. You can't see anything on that screen, is that correct?
That's correct.
Okay, so we should make something visible on that screen. Are there buttons to push?
There it is.
Now you can see stuff on that screen. All right, terrific. That's going to make things go better. Maybe. So good. So I'm here today. My talk today is going to focus, you guys want to move around to see that? You're right. It's going to focus on two stories that are at the center of much discussion of intellectual property law in the United States. The first of those stories is the standard economic story about the role that intellectual property law plays in the creation of valuable new works and inventions. Right? This is the idea that intellectual property rights solve public goods problems in information by providing incentives to creators to invest in new works of authorship or inventorship, and in the absence of intellectual property of some formal type or another, they simply won't. Right? So rather than being poets, in the absence of intellectual property law, people will just go to law school, right? And that would be bad for the world, so instead we create intellectual property protection so that there are poets and not just lawyers, right? And so the second story then is that in the US at least, moral concerns have little or no role to play in the shape and structure and content of the doctrines that we produce. Intellectual property's goal is to optimize creative production by balancing incentives to produce with access to readers and subsequent creators, but there's no real substantial moral component, right? There are these kind of pockets of moral rights that one sometimes sees in copyright law, occasionally in patent law, but in many respects these are the exceptions that prove the rule, that normally what we're really talking about here and some kind of cold, hard economic reality. Right, so these are the two stories I want to start with, and over the course of my talk, I'm going to question both of them. Right, we'll start by questioning the first one over the last decade or so, we've learned that story number one is often incredibly wrong, that in many areas of creativity, we see enormous amounts of creativity, either in the absence of formal intellectual property systems, or when people simply don't use the formal intellectual property systems that exist. So here's a list of some of them. There are many more that could be added to this list as well. Right? In many of these areas, in fashion and open source, in cuisine tattoos, right, you can read as well as I can, right? There are situations in which we see people engage in enormous amounts of creative production, even though intellectual property law, patents, copyrights, trademarks, trade secrets play very little role. So this asks us to question this story. I'm going to look a little bit about the role of chefs here. This is the case study that I've contributed to in some respects, right? So think about the ways in which chefs create. One might think about this as social norms around the professional hearth, Bob, rather than the private hearth, right? So what's going on in elite restaurant kitchens? And what we've seen is that in elite restaurant kitchens, chefs appear to be very good at managing the kinds of creative production that happens. Chefs are incredibly creative. We see all kinds of new terrific dishes, lots of new inventiveness, new ingredients, new techniques, all kinds of things, even though we see basically zero use of intellectual property law. Right? There's one chef in the country that I know of who invests in any degree in patenting his efforts, and most of them don't do anything serious with respect to copyright or the rest. So what factors can we find that affect their ability to do this? And here are a number of them, right? This is relatively small, cohesive, homogeneous groups of people who seem to care, right? Chefs, restaurateurs, critics, the elite diners. Most importantly, for the perspective of this conference, there seem to be a convergent set of social norms that govern appropriate and inappropriate behavior. And then also a number of other factors with respect to the ability to copy or not copy, whether copying is harmful or not harmful, and also whether the internet, which we normally have learned to think of as a tool for piracy, right, in fact, in this case, is a tool for policing what we might think of as piracy. So the famous cases in these situations involve messaging boards, Chowhound and others, in which some diner eats at a restaurant, takes photographs of some dish, posts them online, and then other diners say, that's just like what this other chef is doing at this other restaurant. So the internet then becomes this way of policing piracy rather than promoting piracy. So these are various things that seem to matter to the production, the creative production that chefs produce. The social norms at stake in the culinary community are important in governing the kinds of creativity that we see. And I wanted to discuss, at least briefly, a few social norms that seem to matter most. And at least these first two, I think, are important for considering. It's something that we, as norm scholars of intellectual property law, I don't think spend an awful lot of time thinking about. We almost take this as given from our backgrounds that when people create stuff, they can maybe get some rights in it. So the first one is the notion that chefs could own the stuff that they produce, right? That there is a relationship between the creative production of the chef and the actual production itself, right? That she may get to say some things about how that dish is used by others. Right? This is a norm like any other, but it's one that's often glossed in the literature. The same is true of the promotion of creativity. And this is a situation, at least in cooking, that's relatively novel historically. Right? So prior to the 1970s, creativity was not necessarily something that was sought in the kitchen. Up until at least the beginning parts of the 20th century, the goal of a good chef was to reproduce as closely as possible the canonical dishes of French chefs like Antoine Carême and Auguste Escoffier. And what you did if you knew how to cook well is you cooked the canon properly. And your goal was not necessarily to wow us with new and novel creations. But currently we see this certainly very strong interest in the promotion of creativity. In addition, we see a very strong culture of sharing. There's a practice known as staging. One has to pronounce it with a French accent, I'm told, in which chefs, if they have some time and so desire, can go and work in the kitchens of their putative rivals, spend some time there, learn the techniques, learn the dishes, and then bring them back to their home restaurants. as long as they do the same, and as long as when they copy them, the ways in which they copy them are not perfect substitutes. Right? So if this dish was performed with lobster in the kitchen in which you staged, you have to substitute out and put in shrimp. Something else like that, right? So there's this notion of copying, but not too much copying, no exact copying. And finally, there's a fairly strong norm of attribution, that if you're cooking another chef's dish, if you're either copying it directly or modifying it, there should be, at least within the inner circle, some recognition that this was taken from somewhere else and from where it was taken. So norms about attribution as well seem to matter in these kinds of cases. Scholars of norms have been attracted to these fields for a number of reasons. And this is much of the stuff that we've talked about in our warm-up session. And I think this is a nice way to think about it again, right? So norms-based systems appear to be more efficient in many respects, right? So we see lots of creative production without all of the costs that are normally associated with formal IP systems, right? Transaction costs, fencing costs, administrative costs. Here are a bunch of people who produce an awful lot of stuff that seems to be very creative, and we don't have to set up a formal IP system for them. Terrific. They don't have to litigate. Terrific, unless you're trying to place law students in jobs in which it's not so terrific, and maybe some more litigation would be good, right? But in general, this is thought to be an efficient way to produce, and many of us, I think, are attracted to that. In addition, norm systems seem to be valuable because they're flexible, right? So intellectual property is often incredibly one size fits all. The laws governing books are the same laws that govern movies by and large. And what we see with norms is an opportunity to fight against the rigidity of intellectual property systems. And finally, the existence of norms seems to counteract this general notion that IP is essential, that more IP is better, that one often hears from the IP industries and their lobbies. What I want to do now, though, is think about the way these norms work, the way that they emerge, the way they affect creativity, and the way that we as legal scholars and others should be valuing them and interrogating them. The norms that emerge, that are active in these communities, are ones that represent the moral intuitions and moral psychologies of the people within the communities. So to the extent that we're studying norms, one of the things that we're studying, not the only thing, but one of the things that we're studying is the moral psychologies of the individuals and the communities of creation that we see. Contrary to story number 2, then, intellectual property law in the United States is deeply cathected with moral intuitions. This is true both in more traditional creative fields, ones that are typically governed by formal legal systems, and also ones that are governed by informal legal systems. That people's responses to IP-relevant behavior are deeply shaped by the moral intuitions that they hold. Right? So the project that I want to encourage in this respect is one that, in order to understand the way that social norms work in IP communities, we need to systematically understand the role of moral intuitions. Fortunately, there are smart people in moral psychology departments who are giving us some tools for doing that, and that's what I want to start to do here, to start to think about the ways that moral intuitions map onto the kinds of creative production we see both in traditional formal law-governed creative communities and in informal norms-governed creative communities. The definition of morality here is key, and it's one that is contrary to the definition that philosophers often adopt in these cases, right? So in philosophy, the rules about what counts as morality tend to be ones that have to do an awful lot with reason. They tend to come primarily from the philosophical traditions of, on the one hand, Bentham and utilitarianism, or various versions of deontology, attributable to Kant, or in our case, in intellectual property law, Hegel and Locke. Right? These are the poles of the discussion of morality in intellectual property law. From the functionalist perspective, from the perspective of most moral psychologists, morality is a much broader and much more heterogeneous area of discussion. So here's a quote from Jonathan Haidt, who I think is doing some of the best work in this area. Moral systems are interlocking sets of values, virtues, norms, practices, identities, institutions, technologies, and evolved psychological mechanisms that work together, and this is the functionalist component, to suppress or regulate selfishness and to make cooperative social life possible. Right? So what we see in the choice, such as it is, between formal legal systems and informal legal systems is a choice about the varying opportunities for suppressing and regulating selfishness, making cooperative social life possible through alternative mechanisms, right? So this is the questions that I'm interested in studying. Turns out when we start to look at the moral psychology that's available, it is broadly heterogeneous. It doesn't fall into the categories simply of Kantian, Hegelian, Lockean natural rights theory on the one hand, and Benthamite utilitarian theory on the other hand. At least according to Jonathan Haidt, right, who's doing this work on moral foundations theory, people's moral intuitions about stuff, right, never mind the law, about stuff, right, come from 6 different sets of moral foundations listed here. One cares about concerns about harm, concerns about fairness, concerns about authority, concerns about loyalty, about sanctity, and about liberty. That each of these things play important roles in the ways in which communities regulate selfishness and encourage pro-social behavior. That the world of morality is much broader than what has previously been supposed. So what our goal here, I'm joined by my co-author on this project, Dave Fagundis from Southwestern Law School, is to start to look systematically at the role that moral intuitions play in the kinds of IP-relevant behavior that we might see. To take the moral psychology that we're finding and to interrogate how it plays out in questions of IP and creativity. As we're going to see, each of the moral foundations that I discussed here seems to have some impact on both traditional law-governed creative practices as well as informal norms-governed creative practices. And importantly for our study, the moral foundations that are at the heart of people's responses to IP-relevant behavior are not necessarily the ones that intellectual property law is especially excited about promoting. And that disconnect will be important for us in interrogating how well norms are doing at accomplishing IP's goals. So I just wanted to very quickly show you some examples of where we see variations of these moral foundations in intellectual property. Some of these examples will come from fields that are traditionally law-governed. Some of them will come from fields that are traditionally norms-governed. The harm and care, when this is at the heart of what we think of as intellectual property law, right? It's about this utilitarian bargain, promoting incentives to creators while maintaining opportunities for others. The goal should be to maximize benefits and minimize costs. Interestingly, the costs that intellectual property law typically cares about are simply those, incentives and access. The other realms of costs, in terms of non-economic harms, in terms of dignitary harms, these are ones that are typically outside of the realm of traditional economic analysis of intellectual property law, but nonetheless seem to play important roles in the ways in which people respond. You know, Jack Valenti is always terrific for this. Like Jack Valenti is great for giving us moral intuitions about stuff. Right? So Jack Valenti's Boston Strangler comparison of the VCR. Right? What the VCR is doing to the American film industry is the same thing that the Boston Strangler was doing to women on the streets of Boston. That's how scary it is. Right? That's how much we should be worried about this kind of stuff. Right? And you see this in the way that people talk to kids. Right? Real people get hurt, like J.K. Rowling, when you download stuff on the internet. So, this is not surprising, right? That people care about harm in the context of intellectual property law. People also care deeply, though, about fairness and cheating, and this is the foundation of many of the norms-governed communities that are important to the studies that we have. Sharing and reciprocity, issues that seem to be enormously important in motivating and supporting these norms-based communities are fundamentally about fairness. They're about tit for tat. Right? But notice there are strong in-group, out-group distinctions among these communities about who's in and can take advantage of the sharing and who's out and doesn't get to share. Right? So although there's a moral norm here, the way that moral norm plays out is certainly different in different cases. fairness concerns show up in notions about not reaping where you have not sown. They show up regularly in just kind of general concerns about deserving rights. We've talked about this as well, right? When you ask chefs, right, do you think you should get intellectual property rights? Well, first they say, of course I have intellectual property rights. And I tell them, no, you actually don't in any meaningful way, right? And so, yes, I do, no, you don't. Okay, fine, right? Do you think you should get them? Yes. Why? Because Britney Spears gets them, and I'm at least as creative as she is, right? It's this notion of moral desert, right? That, creativity deserves intellectual property, right? That if you're creative, then you deserve intellectual property. That this desert notion of IP is incredibly strong. It suggests, right, the power of fairness and cheating concerns that to me suggests the incredible strength of sweat of the brow theories of intellectual property, despite the number of times the Supreme Court has to tell us that this is not an accurate theory of copyright law. Nonetheless, people still feel very strongly pulled by sweat of the brow concerns. Authority and subversion is another strong way that people's moral intuitions appear in questions of intellectual property relevant behavior. Right? These are concerned. Parent-child analogies are popular in areas of intellectual property. Rights of paternity, the notion that there are relationships between their creators and their works that are like paternity-like rights, seems to be important in the types of intuitions and norms that develop. And you see actually both sides of this here, right? So mostly we've been playing with the pro-social aspects of these moral foundations, right? But in the distinction between guild memberships, which are very much about authority, and hacker culture, which is very much about subversion, we see both aspects of the foundation at play. And in further ones, in sanctity and degradation, this is the notion that some things have especially strong value merely for their purity. The differentiation in the amount that people are concerned with sanctity and degradation is often highly predictive of how they respond to social issues. Right? So it turns out that whether you are in favor or opposed to gay marriage is often incredibly well predicted based on how well you feel and how strong your sanctity, degradation, moral foundation appears to be. Right? And this seems to be true of many aspects of the informal intellectual property systems as well. Right? There is, I'm told, in the realm of the groups who engage in graffiti, norms about what kinds of graffiti are appropriate, what you're allowed to spray paint and what you're not allowed to spray paint, when you're allowed to deface other people's graffiti and when you're not allowed to deface other people's graffiti. It's an incredibly strong norm against defacing the graffiti of someone who is deceased. Right, so some previous graffiti artist who is deceased, these are called memorial graffito, I'm told. Right, these are ones that are supposed to be left alone and not to be degraded in any way. Loyalty and betrayal. Jack Valenti again, right? This time scared now of the Japanese. Mary Beth Peters scared about the piracy that comes not just from our very college students, but even more scary, the ones that come from Russia and China. And certainly loyalty and betrayal play an incredibly strong role in in-group norms, in questions of disloyalty, liberty and oppression, you can imagine as well. So what should we do with these norms? People confront intellectual property problems from a variety of different moral perspectives. Some of these moral perspectives are ones that are consistent with law's consequentialist goals, and some of them are perhaps less consistent with those goals. So the first thing I want to argue is the mere existence of moral intuitions that violate the law's consequentialist efforts does not mean that we need to shift what we're doing. We do not need to necessarily adopt Lockean or Hegelian natural rights approaches to intellectual property law merely because many people feel those ways about intellectual property law. Intellectual property law can still be consequentialist, but in order to do it well, it needs to understand this stuff at a systematic level. It needs to understand the ways in which moral psychology tends to affect both the norms that we get as well as people's behavior with respect to formal legal systems. Norms still are incredibly attractive in these cases. Fairness and loyalty produce norms of sharing that seem incredibly beneficial. We get lots of creativity and distribution without lots of costs. On the other hand, we need to make sure that we're asking an important question about sharing with whom. Who's in and who's out? Are we happy when norms get produced which make differentiations between groups that we might not like to see? Right? If you're within the guild, you get to share the knowledge of the guild. If you're outside of the guild, then you don't. And this is not necessarily the way that a formal intellectual property system would have established rights of sharing. And so we should be careful about exactly these kinds of problems, and historically one sees them in medieval guilds, Fashion Originators Guild, Trade Courtesy Publishing, about which we'll hear later. There are many dark sides of norms in these contexts as well. The social norms that emerge are not necessarily consistent with the kinds of formal intellectual property protections that we might think are appropriate. When you talk to chefs, they talk a lot about owning ideas. They don't talk an awful lot about owning expression. And in intellectual property law, we make important distinctions between the rights in ideas and the rights in expression. Importantly as well, there are differences in the notion of duration, how long your rights should get to last. They are not necessarily well calibrated towards the incentives and access paradigm that we would normally think about. Labor and originality, I've already hinted at, right? The notion that once you create something, you deserve rights in it, regardless of whether it has originality. Attribution is another field. Attribution norms are strong across very many of the communities that we'll discuss, but the economic value of formal attribution rights is at least subject to some question. Right? Whether there should be formal attribution rights in the law is a debatable question, and despite the fact that we see them very strongly here, it's not entirely clear that this is a good thing. Finally, concerns about fair use and integrity that I've hinted at as well. In each of these cases, the norms that arise may differ from the doctrines that IP law has adopted. We need to be careful when thinking about these situations. Right? Just because there are aspects of IP systems that we find undesirable, their scope, their breadth, their length, the kinds of things that they cover, that doesn't mean that the informal norms that get produced will necessarily result in optimal results either. Social norms may work well for some things, certainly sharing within groups, but substantially less well for other things. It's important to keep in mind that before there were laws, there were just norms. And one of the attractions of laws over norms is that we get to put into place certain rules that may provide protections for people who would not otherwise be well supported by informal communities. And our goal then as scholars should be to harness the power of norms, helping to achieve IP's general consequentialist goals. So thank you very much. I guess we'll have questions later. Is that right? So perfect. Thank you all.
Is Catherine Fisk. She is Chancellor's Professor of Law at the University of California, Irvine, where she was one of the founding members of the law faculty. An expert in the fields of intellectual property and labor law. She's written extensively at the intersection of those fields. And she's also the co-author of 2 case books, one on labor law and the other on the legal profession. I can recommend the latter book. It's really good. Her talk today is entitled Intellectual Property as Labor History. The social norm that Professor Fisk most commonly breaks is the norm against swearing in the classroom. And I have to say that before talking to Professor Fisk, I was not actually aware that there was such a norm. So this will be a very useful conference for me, even if I just learned that. Thanks a lot. Professor Fisk.
I should have thought harder before identifying the norm that I break. I think the social norm that I'm about to break right now has to do with PowerPoint. I don't do PowerPoint. Sorry. I want to join the thanks to Bob for bringing us together and to the Chapman Trust. It's really a great treat to come here and to learn from people whose work I admire so much, and in many cases whom I have not met. So this paper comes from a book that I am in the process of writing, examining the work relationships of writers in mid-20th century film and television, in Hollywood, and in one and part of another New York advertising agency, to explore the roles of law, and more important, especially for present purposes, legal norms in mediating creation, ownership, attribution, and public recognition as dominant features of 20th century authorship. It hopes to be, or I hope the book will be, a socio-legal historical study of labor, employment, and intellectual property, to examine the meaning and the consequences of corporate ownership and control of intellectual property. Hollywood studios and Madison Avenue advertising agencies valued and attributed creativity, but adopted contrasting practices about attribution. In the 1940s and 1950s, which is the crucial period for my book, both industries were in transition away from being dominated by vertically integrated, pyramidally structured, and bureaucratically managed corporations. Men, and actually some women always, in both industries made a huge amount of money by writing if they were successful. They worked in companies where the managers knew, as one 1950s ad executive put it, that the company's most valuable assets rode down the elevator every night. They were the knowledge economy before that concept passed from vogue to cliche. Writers in Hollywood, unlike writers on Madison Avenue, belonged to a labor union, and many of them were pretty militant unionists. Their union, the Writers Guild of America, created the screen credit system that we now have. Film and television writing is unique in American letters in having a worker-controlled process for deciding the meaning of authorship and for attributing authorship to people, and also for compensating workers based on the union's own credit determinations. And it's actually a fair amount of money for getting screen credit in Hollywood. In advertising, by contrast, there were no unions. There was also no formal system of attributing work. Work was attributed to individuals, of course, in private, for purposes that served the interests of the agencies, and in the state as a matter of the kind of common knowledge that defines a community. But it wasn't, as you all know, attributed to noted workers, even when ad agencies recruited celebrity artists of one kind or another to do their work. So the J. Walter Thompson agency that I study hired Edward Steichen, the noted modernist photographer, to do a series of photographs for one of their clients, Jergens, the hand lotion. And he did these very artistic and beautiful photographs of hands, none of which were attributed to him, even though it might have been actually to the benefit of the agency as well as the client to have him sign those photographs when they were part of the ads. The contrast between Hollywood and Madison Avenue suggests that a strong system of employee collective representation leads to greater reliance on binding, transparent, and democratically created legal norms mediating creation, ownership, and private and public recognition. The norms of attribution are strong enough, and in the judgment of both writers and film and TV producers, accurate enough, that substantial amounts of compensation are paid to writers based on the guilds or the writer's own credit determinations. The Hollywood collective bargaining agreements between the writers and the producers create a form of soft law moral right of attribution. It is almost the only form of moral right that exists in the United States, as the copyright scholars in the room know. And it exists only because writers and actors and directors unionized and demanded it. The labor history of attribution practices in Hollywood and on Madison Avenue reveals, at least to me, and I hope when I'm done to you, the significance of unionization to our understanding of authorship of ads and films. My argument is that unionization explains why film and television writers are recognized and compensated for reuse of attributed work, but ad agency copywriters are not. So the Writers Guild is both the motivating force behind screen credit and a necessary institution to enable the system to operate. I think that, and apropos for this conference, the history also reveals the significance of private intellectual property rights, such as screen credit, as part of the overall landscape of intellectual property law. I also hope for the literature scholars in the room, or those of you who enjoy it, to say that the substantial literature on law, history, and literary studies on the nature of authorship, most of the focus has been on copyright law, and I think that's fine. But I think that it overstates the significance of copyright law. In both law and literary studies, scholars have tended to focus on the relationship between copyright law and its definition of authorship and an individual literary model of authorship. The story of intellectual property, as the lawyers conventionally tell it, has a cast of characters usually limited to owners and users. But I think this scholarly focus on authors and owners has been incommensurate to the relatively small percentage of 20th century creative people whose efforts are rewarded or were rewarded through copyright ownership. Once we realize that much modern creativity is exercised in an employment setting where salaried creators sign away their rights in their work as a condition of hire and sign away their very status as authors, we can see that attribution of work rather than ownership of it defines the modern connection between many creators and works of all kinds. The tendency to propertize authorship, which became a tendency to propertize attribution, led to the late 20th century distinction between, the late 20th century blurring of the distinctions among authorship of art, authorship of persona, and celebrity. In the world of commercial cultural production, authorship has been an unstable blend of individual and collective creation and attribution. And what authorship has meant has been determined largely outside the purview of copyright law, and often outside any other formal law, bouncing back and forth, in my metaphor, between the individual and the corporation. Diverse methodological approaches have been embraced by scholars doing sociolegal study of history generally, and this in particular. The approach that I choose to build upon here is Christopher Tomlin's invitation to reimagine sociolegal history or sociolegal study generally, not as law ampersand society, but without the ampersand. Tomlin's proposed the substitution of law as a way to think about the relationship between law and society. He argued for dispensing with the conjunctive metaphor and describing the relationship between law and society not as one between distinct domains, law, society, economy. And so I want to build on that to say that intellectual property and labor are the same domain. One is not constitutive of the other, as scholars like to say. One does not shape the other. They're not even mutually constitutive. They are rather the same. And so the title of the paper, Intellectual Property History as Labor History, is trying to ask historians in particular, but also scholars of norms, to think about the way that norms, labor markets, working conditions enable creative people to produce collective works. And also the way that that then results in the creation of a certain kind of private intellectual property or moral right. So there are lots of metaphors that I'm exploring as I think about this work and that you could think about. Bob Ellickson's seminal work in the field of norms used the metaphor of in the shadow of the law. Chris Tomlins and I use the metaphor of law as. You could say, think of the medium of. There are lots of metaphors that we could think about. And perhaps the theoretical intervention that I wanted to suggest today is an overlapping spatial metaphor. And here's where I probably should have a Venn diagram, but instead I'm just going to ask you to envision it. a series of possibly 4 overlapping circles. I tried to do this on my paper, and I can't actually do it on a document, so there's a reason why I don't do PowerPoint. So imagine, there's one circle that you might call law. There's another circle overlapping it that you might call contract. There is a third circle overlapping each of those, at least in part, that I could label norms. And a fourth, and there might actually be more than one, I have to think about this, that one might label the market. In some cases, they might be concentric circles. In some cases, they might be overlapping. But I think that the metaphors that we use to think about laws, norms, the market, then wind up affecting deeply the story we tell as we are describing the evidence before us. So let me now talk about 2 episodes, one first from advertising and the second from Hollywood, to see how thinking about intellectual property as labor, as a series of contractual, legal, norms, and market-based behaviors and cultures influence the way we understand this. So, in the 1950s, senior executives at the J. Walter Thompson Advertising Agency, JWT as it is now known, which was then the largest advertising agency in the world, opened a new front in their decades-long battle to bring professionalism and efficiency to the management of the creativity involved in advertising. They had created a huge international corporation, producing advertisements and media campaigns for a wide range of clients around the globe, but they had a problem, or at least they thought they did. The need to manage and organize their work required bureaucratic structures of communication among offices and departments, the planning of ad campaigns, cost control and accounting. It required all the machinery of the large mid-20th century corporation, complete with the usual hierarchy and division of labor among who did what. But the challenge that they confronted was how to reconcile that with the kind of bottom-up culture flexibility that they thought was necessary to spark creativity. A flurry of interoffice memos in 1957 explored twin ideas about how they should manage their creativity. One suggested that if it was too bottom-up, and if creative people were in direct conversation with their clients, the whole organized structure in which the account representative, think Don Draper, if you've watched Mad Men, was supposed to be in control of the situation, would fall apart, and that it would be bad for a variety of reasons, some of which are funny, like poor personalities and creative people alienating clients, and also rendering management completely irrelevant and reducing their status in the organization. On the other hand, there are also memos expressing grave doubts about the wisdom of bureaucratic management of the creative process. And their solution to alienation was to propose greater public recognition or greater client recognition of the creativity of individual employees, especially those further down the hierarchy. So that this tension between management and kind of a bottom-up attributed to the low-level person issue was at the core of the fact that they didn't have a particularly well-organized way of managing attribution. For all the talk about modernization at JWT, it surprised me when I started looking at their files how relaxed they were, at least by today's standards, about actual intellectual property rights in employees' work. The firm generally did not use written contracts for its employees. It relied on corporate culture to ensure that employee-generated intellectual property belonged to the firm. And the agency did not always even claim ownership of work that they probably did own. In the days when the agency wrote and produced radio programs for its clients to sponsor, the show's writer might own the script, even though he or she was actually an employee of the agency, not an independent contractor. And this got especially interesting in the late 40s and early 1950s when ad agencies, including JWT, who had long been producing radio programs, started writing and producing television programs for clients to sponsor. And indeed, in the first round of negotiations between the Writers Guild, or the predecessor of the Writers Guild, over television writing, and the film studios that were producing TV programs, the ad agencies were also at the negotiating table because they had had that role when they were dealing with radio writers. And indeed, in October 1948, a committee of advertisers engaged in negotiation with the Radio Writers Guild, which was the union that represented writers in radio, and for a while thought they might be the union that represented television writers. It then got complicated. In any event, this negotiation proposed a list of issues for discussion that on the topics in which the advertisers and the guild had not been able to agree. Among the points of contention were the definition of employees to be covered under any collective bargaining agreement and the property rights of sponsors and writers in scripts. Interestingly, money was not on the agenda of issues to discuss because the agency anticipated no difficulty reaching agreement with the guild on this score. So this question of was the agency going to own it, was the sponsor going to own it, or were the writers going to own it, was regarded as quite up in the air. It was also interesting that they couldn't figure out what to do about attribution, because by the late 1940s, early 1950s, it was already established with film that the guild controlled screen credit. That was established in 1942. But it was on radio, in part because airtime was so short, there was much less attribution, and so there tended to be less conflict between the norms of non-attribution that dominated print advertisements and the norms of attribution that governed film, and whether television was going to look like radio, which was a little bit more like magazines, or was it going to look like film, which had much more attribution. And it was interesting in particular that JWT had sort of prided its corporate culture on no attribution. The longtime head of the company, it was said, would never let anyone have credit for even an ad. It was a company job. The whole thing was company, no one person. Another copy editor, who later became noted for his book, A Night to Remember, which was about the sinking of the Titanic, said, the Thompson Company deliberately beclouded the matter as to who was responsible for a particular ad. Mr. Resort, the head of the company, believed so firmly in the team idea that an individual is never known as the person who wrote such and such an ad. Keep yourself out if you want to get your idea across, is the cardinal rule. He said, we depreciated titles. We didn't have labels or titles. We didn't sign our name individually to projects. We signed our work, J. Walter Thompson, said another employee. This wound up being quite controversial in the early days of television. The JWT General Counsel, longtime General Counsel, reported to colleagues at the firm and to clients that writers on a JWT-produced radio show repeatedly asked for air credit, and the company consistently refused. And so that had been a pattern, but during the 1948 negotiations over the collective bargaining agreement with the Radio Writers Guild, executives at the agency expressed concern that recognizing a union for its radio writers would require air credit to be given to writers, which JWT had never done, and that would start to collide with the way that they didn't also attribute print work. As one executive recalled, as you look back at the credits for writing, directing, and producing these and other JWT shows, Another striking thing stands out. The credits look like a roster of JWT radio department talent. In those days, JWT wrote all of the material their stars used on the air. The stars might be getting $5,000 to $7,500 a week, and the writers and directors might be getting that much a year, and no credits on the air or in the trades. Ours was an anonymous society, and our only accolade after a particularly fine show, and one which broke new ground, was an orchid, which we would find on our desks the morning after from the JWT vice president. So they privately, of course, and within the world of ad agencies, JWT did attribute work to itself. Obviously, we've seen that as a firm, and to individual employees. Attribution was a strategy of bureaucratic rationality. So those in the industry knew who had which account and which agency was responsible for which campaign, and creative directors received awards for the work of their team at annual awards banquets. Generally, it was very informal, and they tried to becloud the question of how work was attributed. Yet, of course, they needed to for their own internal management. They needed to know who was particularly creative, who was particularly good. The company newsletter, and I've read all of them for the whole history of the company, and it was published either weekly or bi-weekly for decades, routinely profiled individual employees and often attributed slogans, ideas, or other aspects of ad campaigns to particular people. For example, you could read that it was certain people at the Chicago JWT office that developed the well-known Uncola 7-Up campaign that I remember from my childhood in the early 70s, or some that I don't remember. She's lovely, she's engaged, she uses Pond's, which is a known campaign apparently in the 1940s. Company lore lionized the accomplishments of particular creative employees as a way of dignifying leaders and inspiring young people, but it was ad hoc, and it seems like it was discretionary with upper management. This all might have become enormously problematic as television grew if ad agencies had continued writing, producing, and directing and filming television campaigns. But as we all know, they didn't. The strategy for television changed, and JWT began just doing the 30 or 60-second spots in between shows written by other people. And thus, at least film advertising wound up going in the direction of film. So, the story of screen credit. Now, come with me briefly to Hollywood. I know I'm short on time. The desire for screen credit emerged very early on in the history of Hollywood television writing. In the early 1920s, as film writers formed a branch of the New York-based Authors League of America, and at the time were describing themselves as a professional association, not a union, they complained frequently about, writers that is, complained frequently about their inability to secure through individual negotiations enforceable contract terms requiring studios to credit writers accurately or to mention them in advertising for films or other film publicity. So from its inception, and the Guild fell apart in the 1920s and early 1930s, and then grew again in 1933 in the Depression, and was recognized finally after a legal process in 1938. One of the first things on the agenda was screen credit. And so in 1942, in January of 1942, when the Writers Guild secured the first collective bargaining agreement governing film, it was a very short agreement, only 5 pages long. Today it looks like the phone book. But it stated then, and it states still, credits for screen authorship shall be given only pursuant to the terms of and in the manner prescribed in the collective bargaining agreement, which doesn't say much, and the screen credits manual, which is developed by the Writers Guild unilaterally without the involvement of the studio. It is drafted by Guild members. It is voted on by Guild members. It's incredibly complex. I've written about how it works, and I'm not going to talk about that here. But it's important to note that the Guild is very legalistic in the way that it goes about both developing the screen credit rules. It's a democratic process. There are committees that propose changes. There's long debates. It's voted on. And then it's also both procedurally and substantively complex as applied. There are arbitrations governing disputes over screen credit in film. They are not appealable on the merits at all. And the Guild has run a very successful legal campaign over the years preventing courts from deciding any disputed credit issue on any legal theory, and lots have been tried. Individual hiring contracts for writers supplement the minimum basic agreement between the Guild and the Alliance of Studios and Producers on a whole slew of issues. Individual contracts are very long and detailed. They claim for the studio or the network all the intellectual property rights in everything that the writer does during the term of the agreement, and they have for a very long time. If you look back at agreements from the 1940s, for example, the agreement from 1946 between James Webb, who was the credited writer of How the West Was Won and Cape Fear, and a whole slew of westerns and thrillers in the 1940s and 50s. That agreement, he was a successful writer and was paid a fair amount of money. He promised not only to render whatever services as a writer the studio might require at whatever time and place the studio might demand, but also granted to Warner Brothers the right to exhibit any film on which he worked, on radio and television, and all other improvements and devices which are or may hereafter be used, and gave the studio all rights whatsoever in and to all and every of the works that he shall write, conceive, compose, or produce during the full term of the agreement. So very detailed, giving all the intellectual property rights to current and future IP to the studio. But on screen credit, the agreement was very short. It shall be determined according to the collective agreement. As I said, a lot of compensation turns on screen credit. So it's not just the right to residuals, which is compensation for reuse of film, and the Guild spends a fair amount of time administering the residual system because it's complicated and it requires a lot of policing and a lot of accounting. There is also a system of credit bonuses for film writers. If they wind up as the credited writer, they get paid a bonus. All of it turns on the Guild's credit determinations, and the process hasn't changed that much since 1942. The rules require a committee of 3 arbitrators to decide any disputes among writers about who's the writer, looking at all of the literary material, every version of the script, a treatment, the novel, if it was based on a novel or short story, along 4 aspects: plot, characters, scenes, and dialogues. And there are percentage rules for who will get credit based on the degree of their contribution to those 4 elements. When I began working on screen credit, I imagined that there would be law governing how credit was allocated. And of course, I discovered there isn't. So then I discovered that there is the minimum basic agreement. And I thought, oh, that's it. That's a contract, and it's forcible through arbitration, and that's going to determine how credit is allocated. And as a lawyer, I thought, oh, thank God, I've at least got some law to study here when I'm writing about attribution. And so you could read credit arbitrations, and I have, and look at all the rules, and it looks a lot like what lawyers do. But then I started interviewing working television writers for a different project in the last year. I've interviewed about 36 working television writers, primarily in scripted dramas. And what I've discovered is that that whole arbitration machinery that I just described to you doesn't really actually describe how credit is given. What they all say is that the writers in the room, and the room is both a physical place, it's conference room, as well as a metaphor. It refers to the group of people who write on a show, decide somewhat informally who is going to get the assignment to write a script. And the norm is that everybody gets an equal number of scripts to write, with the possible exception of the writer's assistant, the most junior person, who will get less. And if they're sticking with the norms, the showrunner, who is actually a member of the Writers Guild, is technically labor, although really they're management, but if you're a labor lawyer, you didn't hear me say that. They look a little like management, let me just say that. The norm is that the showrunner will actually get less, because the showrunner is the most highly paid person in the room by far, usually. And so they divide up who gets responsibility for writing a first draft of a script. And then they all say, but then who actually winds up writing the script? Oh, it really depends. And what they wind up is getting screen credit on a script that was heavily contributed to by their colleagues in the room, that might have been heavily rewritten by the showrunner, or not, depending on the norms. And so the last thing I want to say about norms, we were having a discussion in the warm-up conversation about what even the norms are for attributing work. And if those of you who pay any attention to this may know that Matt Weiner, the creator of Mad Men, is widely accused of violating the norms governing putting names on scripts. And since it's never arbitrated in television, unlike in film, there's sort of no way of testing it. Although other people will say, and Weiner himself will say, actually, the reality is that if you think that the name on the script reflects who wrote it, then Matthew Weiner does deserve credit, because he does write them all. Contrast, interestingly, the way people think about David Milch, another auteur showrunner, who is widely regarded as having written just about every word of Deadwood, which is a really great television show. Nobody complains that first of all, he didn't put his name on every script, even though everybody says, oh, he wrote it all. He gave other people credit. And so you get this really complicated question of, what does the name on the script actually mean? That David Milch wrote it, everybody thinks David Milch wrote every word of Deadwood. That Matt Weiner wrote it, everybody thinks Matt Weiner wrote a great deal of Mad Men, and yet one of them is regarded as a norms violator by many, one of them is not. And so all of that suggests to me that ultimately figuring out how we even understand what norms are is enormously complicated, which means we'll never run out of things to say. Thank you.
Our last speaker is Lior Strahilevitz, who's the Sidley, is it Sidley and Austin, or is it Sidley Austin?
No, Sidley Austin.
Just Sidley Austin, Sidley Austin, right? One word or two?
2 words.
2 words,
No
Sidley Austin, professor of law at the University of Chicago Law School. He's a co-author of the leading textbook on property law, and has written extensively about privacy, information, and intellectual property. His talk today is based on a paper that he co-authored entitled Don't Ask, Must Tell, and Other Combinations. The social norm that Professor Strahilevitz is most offended when others break is when people break the rules at stop signs. Now I have to add to this that unfortunately Professor Strahilevitz has to leave the conference after our presentation today. So if you run into him out in the parking lot, you should yield if it's your turn to yield. All right, and I will yield now.
Thank you, and I should clarify, I'll be here all day, but I have to head back tomorrow morning, unfortunately, which means I'm going to miss a lot of great ideas tomorrow, to my regret. Let me get the appropriate PowerPoint up here, and while I'm doing it, I want to reiterate, there we go, I want to reiterate the thanks that that's been voiced by my co-panelists. Everyone in Tulsa has been really a fantastic host, so thank you for that. So this is co-authored work. It's with my friend Adam Samaha at NYU Law School, and we sort of undertook this as an experiment. We were aware of the Don't Ask, Don't Tell regime, as everyone in the room is no doubt aware of it. That was, of course, the regime that governed gay and lesbian service members in the military from 1993 to 2010, when after even decades of criticism, President Obama signed an order repealing the Don't Ask, Don't Tell policy. So we're interested in Don't Ask, Don't Tell, but more broadly we thought, well, that's kind of an interesting combination. Don't ask, don't tell. Surely there are some other legal regimes or social norms that have the same funny combination of restrictions on asking and restrictions on telling. And wait a minute, maybe there's even other combinations we might imagine. Must ask, must tell. Is there anything like that in the American law? Don't ask, must tell. Well, it'd be really funny if we found something like that. Must ask, don't tell. Well, that wouldn't seem to make much sense. So we started off, again, in a very experimental project, trying to figure out, as a first matter, whether we could brainstorm for other policy combinations that either mandated or prohibited the seeking of information or the provision of information. And lo and behold, as I'll suggest in a little bit, turns out there's a lot of law out there. It turns out there's a lot of social norms out there that might fall within this typology. So once we started to have some success in brainstorming, then we said, okay, well, it'd be really ambitious if we could try and identify patterns and provide a descriptive account of why legal regimes or social systems coalesce around a particular combination, right? Is there anything that these must ask, must tell rules have in common? Is there anything that these don't ask, don't tell rules have in common? And then finally, we said, well, in legal scholarship, typologies are kind of interesting and maybe a fun new lens to look at the law, but the best typologies are those that open up new avenues for legal reform. The Calabresi-Melamed framework being the most successful of these. What they did with their approach to property rules and liability rules was highlight that there was one of 4 boxes that had largely been missed and provided some opportunities to regulate in ways that the 3 obvious boxes didn't seem to do so well at. And so we are going to try in this project to identify sort of new tools that might not be obviously apparent before we start thinking about the law and social norms with this particular framework. So in the draft paper that I'm happy to share with anyone and that should be on SSRN within a couple of weeks, we have an even bigger version of this chart, but these are some of the examples of the typologies that we developed in the paper, and the ones that are written in, it's actually sort of lighter red, the ones on top, tend to be legal rules, and the ones that are bolded or in bright red, those tend to be social norms. Although I think probably in the upper right quadrant, codes of silence, and here we mean sort of decisions by law enforcement not to cooperate with internal investigations. Those are probably more norms than law. But as we sort of work through these examples, and I'll talk about a lot of these different instances, we found, yeah, it's interesting. We can really fill out this matrix with both law and, in every case, norms that seem to encompass these particular combinations. Okay, so I want to work through each of those boxes and tell you a little bit about what we think might be going on in each of the 9 boxes. But just a couple of clarifications and caveats. I mean, I think instinctively, what counts as a and what counts as a don't might not always be so clear. It might be appropriate to think of a spectrum with must at one end and don't at the other end, and may encompassing a large space in between. But even within the box of must, there's really must. You go to jail if you don't comply. And there's a weaker but still rather powerful form of must of you'll be shunned if you don't, or you'll fall and your reputation will fall in the estimation of your peers. So I think we want to embrace the idea that there is in fact a spectrum, and we're necessarily going to use these categories, which are at least in some cases crude. Having said that, we think there's enough easy cases of things that uncontroversially look like musts or don'ts to where the typology that we develop has some descriptive value. And then I think the other thing that's worth conceding, highlighting even at the outset, is that oftentimes the combinations that we're going to describe are sort of a short-lived interaction in one that involves multiple steps, right? So sometimes interactions really are some person asking and some people telling, but oftentimes there's something that came before, there's something that came after, and so some of what we'll do in some of these instances is snip out a little piece of that longer interaction, maybe among repeat players, some other variables. Which party moves first might matter. In some of the examples we'll talk about, the conversation is initiated by the asker. In some instances, it's going to be initiated by the teller. In some instances, answering is made contingent on asking. In some instances, that won't be the case. So be on the lookout for that as I work through these examples, and please feel free to call me where you think that we're playing fast and loose in ways that are important. Okay, so the center box in our little Hollywood squares was occupied by may ask, may tell. And we think that may ask, may tell probably describes most of the legal landscape. Right? Why is that? Well, a couple of reasons. First, it would seem as though there's a good libertarian rationale for why, for the large part, the state doesn't want to force people to ask questions or prohibit them from answering questions. Usually the individuals have better information about whether they should be asking questions, whether they should be answering questions, than legal actors do, than the state does. And we should expect, as a general matter, that the state is only likely to step in where there's externalities at play, where there's third-party effects that result from people either answering questions or posing questions. Another reason why we might expect to see quite a lot of permissive regulation or non-regulation, may ask, may tell, is that a lot of the issues we're going to discuss are quite complicated. Okay, so in the paper we give the example of to what extent should the legal system regulate reference checks. Okay, I'm a restaurateur, I want to hire a waiter, and I've got to decide whether I should call that waiter's prior employer to figure out, was he a good waiter or a bad waiter? It's actually a pretty complicated question. It affects worker mobility, it affects the prevalence of discrimination, it might affect antitrust issues, right? There's a lot, it's a simple question of should I ask for references or not, actually has a lot packed into it. And indeed, we see a lot of heterogeneity there. Those of you who are professors probably know that there are some law firms that always call you if you're listed as a reference, and other law firms that never call you if you're listed as a reference. That tells us, I think, that a may ask, may tell regime probably has a lot going for it in light of that heterogeneity and the complexity of answering in a one-size-fits-all manner whether either checking references or offering reference information should be prohibited or encouraged in any way. Legal doctrine, to be legal centralist for about 20 seconds. The First Amendment obviously is going to have a lot to say about various state restrictions on questioning or talking. Right, that should be clear. We don't spend a lot of time on that in the project, but it's certainly going to create a lot of negative space which the law simply can't occupy. Now, interestingly, and this is a tentative observation, while we think that may ask, may tell is quite prevalent in law, we think it's maybe not so prevalent in the realm of social norms. So if you think about interactions with strangers, there's so many unwritten rules about what you should ask and what you shouldn't ask. People tend to be guarded in their interactions with strangers. There tends not to be so much questioning, and sometimes the questions that do get asked of strangers, how are you, is meant to be answered in a completely uninformative way. Okay, so that brings us to the four corners. Don't ask, don't tell is the military one. I won't spend a lot of time on it because I think it's probably the one set of regulations that everyone in the room is familiar with. People aren't necessarily familiar with all the nuances of that policy, which survived for about 16 or 17 years. Military recruiters and enlisters were prohibited from asking about whether an individual seeking to serve was a homosexual. But military officers weren't barred under the policy from asking later on, and even investigating someone's sexual orientation. Service members were barred from talking about their own homosexuality. They weren't barred from discussing their own heterosexuality, which was a strong basis for criticism. And moreover, individuals in the military weren't barred from discussing other people's homosexuality. So don't ask, don't tell could have been broader. There's important ways in which the regime, as it was actually written, deviated a little bit from the public understanding of it. Now, that facet I noted, that military service members could say, I'm a heterosexual, or statements that would cause someone to infer that they were a heterosexual, presents at least a theoretical danger of what an economist calls unraveling, right? So unraveling occurs where there's two different types of people, let's say, two different types of people, could be more than two, and let's say a desired type and an undesired type, and the members who belong to the desired type all voluntarily disclose their membership in that group, which causes the decision maker to infer about those people who haven't said, I'm a member of the desired group, causes them to infer that they must be a member of the undesired group. So at least in the don't ask, don't tell context, you might, as a matter of mechanism design, worry that all the heterosexual service members will say, I'm straight, and indeed there's a lot of straight sexuality talk in the military, leaving officers who might wish to discriminate against homosexuals not so much of a Sherlock Holmes operation to deduce who it is that belongs to members of this, at least from the military's perspective, undesired group. Okay, but the military context isn't the only instance of don't ask, don't tell. We find quite a lot of it in anti-discrimination law. Not all of it written into the statute. In fact, very little of it written into the statute. There are some federal regulations dealing with questions about disability or family status. If you're a recipient of federal funds and you ask those kinds of questions, you could lose your federal funds. But by and large, the legal bar that we often hear about, don't ask about their race, don't ask about their marital status, don't ask about their religion, it's not coming directly from the statute. Rather, it's coming from prudent litigation avoidance strategies, right? So if I ask someone about their religion during a job interview and subsequently they don't get hired, all of a sudden, even if it turns out my question about religion didn't have anything to do with whether they got the job or not, they've got a very good chance of getting past summary judgment in a Title VII suit against the employer of the person who asked the question. So general counsels tend to say, don't ask these sorts of questions, and it's emerged as a sort of common law of legal counsel advice. In other settings, in anti-discrimination law in particular, the law is going to permit voluntary disclosure, and yet social norms are going to step in to constrain voluntary disclosure, especially when people belong to a minority group. Okay, so we might, for example, expect that Muslims simply won't be forthcoming. They can disclose their religion in an environment where they expect to encounter some anti-Muslim bias, but they won't. They won't do it because there's a strong norm within that community of guarding your religion, at least until after you've been offered the job. Okay, other examples that are more norm-like, I think a somewhat famous one is that a lot of orchestras have a don't ask, don't tell regime with respect to picking the best musicians. So they will have a panel of 5 musicians, the musical director and a concert master and a few others, who will be listening to people audition, but the musicians will be auditioning behind a screen so that none of the people evaluating their fitness for the orchestra will know whether they're white or black, male or female. And indeed, oftentimes in these auditions, musicians will remove their shoes as they walk across the stage so that the trained ear can't tell the difference between high heels and flats, which might reveal some aspects of the identity of the musician. And the thinking there is, we'll get a better orchestra if we can ignore visual evidence, if we can ignore a certain kind of auditory evidence, and just listen to the music, and just put together musicians that way. Okay, so what's going on in this box? Well, we think that a lot of the time when the legal regimes arrive at these combinations, they're trying to prevent this unraveling dynamic that we talked about. Right, you limit voluntary disclosure precisely so that people can't draw pretty reliable inferences about an attribute that the legal system would prefer decision makers not know about. I think there's something else going on in addition to that in the military context, and that's, I think, an effort at norm manipulation. I think the proponents of don't ask, don't tell in the 1990s were pretty uncomfortable with the idea of gays serving in the military, right? They might have preferred, many of them, to exclude gays from the military entirely. And by driving homosexuality underground, they might have thought that that would increase the stigmatization of behavior and therefore cause, frankly, less homosexuality, right? There does, in contexts of homosexuality discussion, oftentimes seem to be a contagion fear. And my guess is that some of that helped motivate the compromise that led to Don't Ask, Don't Tell in 1993, as well as an effort to, by folks who were, let's say, more well-meaning, to prevent gay service members from being harassed. If they couldn't be as easily identified, then it was harder to harass them. Okay, Don't Ask, Don't Tell also exists, we'll argue, in law, in social norms. So a place it shows up, I think, most clearly in law is in the context of clashing workplace regulations. There's a number of different legal restrictions that arise with respect to asking questions about disability as part of the Americans with Disabilities Act. And yet at least there's a subcategory of disabilities in which the employee has a duty, grounded in tort law, to disclose the disability to his or her employer so as to protect third parties, right? So imagine a communicable disease that can be transmitted if precautions are not taken, but won't be transmitted if appropriate precautions are taken. There, the employer likely has some tort duty to disclose, but the employer has an obligation not to ask. At least arguably, I think this example is a little bit less clean, but the Tarasoff context, which involves the California Supreme Court case in which a therapist is required by law to warn a third party whose life is credibly threatened by one of their patients. So the way Tarasoff works, again, the obligation to disclose a danger to the third party is entirely on the therapist. A third party who might worry that someone poses a threat to them actually is in somewhat triple ground asking therapists about whether any threats against them have been made for reasons having to do with, again, tort liability for induced breaches of confidentiality. We think at the end of the day it's unlikely that someone would be sued in those circumstances, and yet not altogether out of the realm of possibility, at least in some jurisdictions. And this is an example that I'm very fond of because we do have some pretty nice empirics. Don't ask, must tell, we argue, is certainly the aspirational and probably the adhered to norm with respect to marital infidelity. Okay, so the literature on this is quite interesting. We've been diving into it lately. Sidley and co-authors in a 2013 paper went out and surveyed people and tried to get a sense of what the norms are with respect to marital infidelity. And emerging out of their research is this idea that it's wildly inappropriate most of the time to ask your spouse whether there's been cheating, but wildly inappropriate to cheat without telling the party who's been cheated on, at least in a marital relationship. Now, more interesting still, I think, is the research by Afifi and co-authors from 2001, which actually surveys a whole bunch of people who've been either the perpetrators of or the victims of cheating in romantic relationships, and then tries to figure out, well, how, if at all, was the infidelity disclosed? And it turns out that in those instances where the cheating partner disclosed the infidelity to the cheated upon partner, only 44% of those relationships dissolved. But where the, let's say, a suspicious partner actually asked the cheating partner whether there had been infidelity, 86% of those romantic relationships dissolved. Indeed, asking whether you've been cheating on me and having that confirmed, although this wasn't statistically significant, was even more correlated with relationship dissolution than catching your lover in the act, which was striking. So what's going on there? Well, I don't want to make a causal claim. I think it would be inappropriate to make a causal claim. It could be that the sorts of people who are committed to the survival of a relationship are the ones who are voluntarily disclosing this information. But it could also be that in these trust relationships, when you voluntarily make a disclosure, you're sending a signal that you're interested in ending the dishonesty. And moreover, you're avoiding that awful confrontation in which these deepest, darkest suspicions, which for so many people represent worst nightmares, actually have to be brought out into the open in a trust relationship. I think Catholic confession has some interesting similarities and is another example of don't ask, must tell. But let me shift over to must ask, must tell. Quite common, right? Here, there are various instances in which, rather than don't ask, don't tell, where generally the legal system doesn't want the information to come out, in must ask, must tell, we really want the information to come out, and we're worried about agency problems, principal agent problems. So we have tax forms that are sometimes extremely precise, or we have government background checks that ask lots of questions, some of them very invasive, or we've got rules about the purchase of alcohol, tobacco, firearms, where there's a script that needs to be followed and needs to be answered. I think the concern here is that the government provides these scripts because it's so concerned that people will take shortcuts. The government's agents will take shortcuts and not ask those questions which are very unlikely to be answered in the affirmative, but if they are answered in the affirmative, the government really, really needs to know about it. There's also, I think, norm examples of must ask, must tell. My co-author is very adamant that when you meet a toddler, you have to ask how old they are. That seems to be about, I'm not sure I agree, but that seems to be about being inclusive, showing an interest in others. What is interesting, and again, he's adamant about this, is you're supposed to ask very old people how old they are too, but let's say between the ages of 7 and 94, it's verboten to ask how old someone is, which is interesting. We'll talk more about that. Must ask, don't tell. This is Tim Russert. We've asked Senator Obama 4 times whether he was going to run for president, and in each of those 4 instances, the answer was no. Turned out that wasn't going to be the final answer. So must ask, don't tell arises in these sort of kabuki structures where the journalists really want the politician to say they're going to run for president. The politicians really don't want to say, they want to make that announcement later. And so you have this song and dance. And we think codes of silence that I referenced earlier have some of the same dynamics. But we see this too in formal law. We'd argue that you see it in civil discovery, where, at least in a high-stakes case, the lawyer seeking discovery is going to ask tons of questions and really broad questions, many questions which he knows the other side can't answer because the answer is going to get them into privileged or work product protections, and yet the questions are asked anyway, and all of the obligations to not tell are imposed on the lawyer responding to the request for discovery. There's Model Rule 4.4b, which tries to deal with circumstances in which a lawyer erroneously hands over the information. Then we get into this strange world of must ask, don't tell, must tell. So I've got to ask you the question, you shouldn't give me the privileged information, you do, and then 4.4b says in certain circumstances, having received the privileged information, I then have to tell you, no, you made a mistake here, I'm not going to look at it, take it back. We think, though, what's going on in these instances, really in all of them, is a world of warring factions. We've just got fundamentally diametrically opposed values that are coming into conflict, and the legal system or the social systems simply tolerate these clashing values and indeed sort of embrace the adversity that arises in these rules. Okay, I'm going to spend much less time on this, but there's interesting stuff happening in what we call the partially permissive rules too, where the legal system or a social system is combining a may with a must or a may with a don't. So for example, don't ask, may tell. A nice instance of that is going to be in the context of an acquaintance's disability, right? You don't ask. But if someone wants to tell, okay, that's fine. Or in labor law, to pick up on an earlier discussion, an employer can't ask a worker during a unionization drive whether that worker supports the unionization campaign. Why not? Questions regarded as coercive. But at the same time, the worker can certainly volunteer interest in supporting unionization. Indeed, if they couldn't volunteer that, it'd be likely that unionization campaigns would have a hard time getting off the ground. Must ask, may tell also arises in disability law and police interrogation. May ask, must tell, that's basically the FOIA regime and also the regime involving mandatory reporters of child abuse. May ask, don't tell, there's a nice property example of that with respect to race. I can ask my real estate agent what the racial demographics of a neighborhood I'm thinking about buying in are. She can't answer that question. There, I think what the law is trying to do, it really is trying to inhibit these information flows, but it's recognizing that one of the parties to that conversation is sophisticated, the real estate agent. The other one's not, and therefore it's going to be really hard to regulate my asking, really easy to regulate her telling. So one hypothesis, which we consider in the paper, is that the only thing driving the law and the social system's choice among these various boxes is use. When we don't want the information to get used, we put it in the don't boxes. When we want the information to get used, we put it in the must boxes. That does pretty well with some of our categories. It doesn't explain the complete picture, and so what we try and convince readers of in the paper is that there's a lot of other values that are going on. So for example, in police interrogation contexts, it's not that we don't want the police to use the information that might get disclosed in a course of interrogation. It's that we're trying to control the mechanism by which that information is extracted and prevent police overreaching. Or in the context of non-disclosure obligations, right? It's not that we necessarily don't want the information to come out, it's that we want safe spaces for discussion and reliance. I think in the world of big data, which is now the world that we're living in, we're seeing a lot of circumvention techniques where in a conversation between A and B, A could ask B, but instead asks C, someone else, maybe a data broker or Google. We're seeing a lot of that. And indeed, one of the things we postulate in the paper is that increasingly there'll be more and more duties to ask C rather than asking B, the first party, for information that turns on, say, fitness for a job or other opportunities that B might be potentially interested in. Okay, so my penultimate slide, so what? Well, I promised that at the beginning that what we were trying to do was open up, sort of use this toolkit to open up new reform possibilities. So let me just try a few of them out on you. I don't want to convince you that any of these are necessarily good policy changes. I think I want to convince you that they're interesting and that maybe the toolkit we've provided might allow you to brainstorm about the legal areas that you know best. Okay, so let's talk about litigation. Okay, so litigation in the United States extremely adversarial. It's a must-ask, don't-tell regime, right? We say in the paper, what would it look like if we tried to reorient civil discovery and high-stakes cases to a don't-ask, must-tell regime, right? The lawyers for each side would have to stand up as part of pre-settlement negotiations and say, here are all the skeletons in our closet. Here are all the terrible things about our case. Here are all the good things about our case. Here's where we think we're strong. And then the other side has to do likewise. And 1 out of every 20 cases, an auditor has to come in and make sure that the parties weren't holding anything back. We think that there's some ways in which that would be a better world, some ways in which it would be a worse world. It sounds crazy, and yet at least in the criminal context, Brady obligations on prosecutors kind of look like that. So at least they're one-sided. Or to take another controversial example, and this will be my last one, maybe where a company is sued and enters into a consent settlement with respect to gender-based pay disparities, right? One of the really interesting findings from economists is that men and women negotiate in firms for raises differently. Men are much more likely to ask what coworkers are making than women are. And when they're told, when men are told what their coworkers are paid, they ask for more. When women are told what their coworkers are paid, they ask for the same. These are pretty pronounced trends that show up in the economic data. So what we say is, well, if a company is discriminating and there's these disparities that are persistent and they enter into a consent decree, maybe it wouldn't be crazy to have the rule be don't ask, don't tell for male employees and don't ask, must tell for female employees, right? There have been various proposals out there, including pending legislation in Congress, the Paycheck Fairness Act, that try and solve the problem of gender pay disparities through transparency. But if men and women have these differential tendencies, then transparency could actually undermine the cause of gender pay disparities. Maybe something that says, look, we know that men and women respond to the same information differently should lead us to a world where we give them different information as a means of addressing these pervasive inequalities. Okay, so maybe during the Q&A, I can explain why I have a scene from The Graduate on my last slide, but I won't do that. I'll leave you curious about it. Thank you.
Okay, I am going to break the rules. I am officially the moderator of this panel, but I'm actually going to comment quickly, mostly on Professor Strahilevitz' paper as a way of commenting on all the papers and indeed most law and norm scholarship generally. So we're going to do this very quickly, but I'm usurping the role of moderator, usurping the sort of function of a commentator for my role as moderator. So this is the paper with Professor Strahilevitz and Professor Samaha, and it's forthcoming in the California Law Review. And there is so much in this paper, as you probably undoubtedly have realized from how much was in the presentation, which is really just a fraction of what's in the paper. I am going to focus on one statement that they basically throw away, right? And it's this statement right here. Attorneys are usually duty-bound to maintain client confidences unless the client decides to waive the privilege. Now, those of you who are practicing lawyers will have spotted the mistake perhaps already. Slight mistake. It's not, I mean, whatever. It's, who cares, right? It's that they're mixing the duty of confidentiality with the attorney-client privilege. These two things have different sources. The duty of confidentiality comes from the rules of professional conduct. The attorney-client privilege comes from wherever it comes from. And attorneys can waive, the nightmare of every young attorney is that they will waive attorney-client privilege inadvertently. It's not just the client who can waive the privilege. But this is not a professional responsibility class. If you want to talk about this for a couple of hours, we can talk about it. What I want to sort of point out is that even if we revise the statement to say something like attorneys are duty-bound to maintain client confidences unless the client decides to waive the duty of confidentiality, that there are some really interesting things that we can say about this statement that might reflect how what I'll just call normativity works in the community of lawyers in a particular place and in general. So there are two questions that this statement, and statements like this, statements of what norms are, often neglect. There are two questions that would be really important if you were interested in sort of philosophy of language or logic, but would be less important if you were not so inclined. The first kind of question that you might ask is a question about what is sometimes called directionality. This is a really fancy word that basically means who is wrong, if anyone. So it could be that the client in particular is wrong when the attorney breaks the duty of confidentiality. It could be that the legal system as a whole, or attorneys everywhere, are wronged when the attorney breaks the duty of confidentiality. How we resolve that question depends on how we conceive of the duty of confidentiality, right? If it's owed particularly to the client, which in some formulations it is, it's a directed wronging of the client to break the duty. If it's owed to sort of the legal system generally, or if it's owed as part of a professional norm, and this sort of tees up Professor Alexson's talk later today, it might be that the profession as a whole is wrong when you break confidentiality. Different people justify confidentiality in different ways. Some people justify it in a way that resembles it being a non-directed duty, in which case breaking it is like polluting. It's wrong, but it doesn't wrong anybody in particular. Some people justify confidentiality as a directed duty owed to the client, in which case breaking it wrongs the client in particular. I'm not here to defend either of those views. I'm just here to say that there are two views about it, right? That for any norm, we might ask these questions about directionality, and that these questions are, in general, neglected in discussions of norms. So for those of you who are going to be here for the rest of the conference, not to put the other presenters on the spot, ask them what they mean when they say there's a norm, right? Because this is part of it. A second thing that you might, so here's client might be wrong, everyone is wrong if it's a non-directed duty. Sorry, that was supposed to pop up earlier. The second question you might ask, and this is really, I think, at the heart of the typology that Professor Samaha and Strahilevitz present, is the question of modality. So the way that they present the, which is basically, what is the norm operator? What term is actually encoded in the norm? And this is really, really important because different operators might result in different ways of specifying the norm and living up to the norm and not living up to the norm. So the way they present is that there are three basic typologies that apply both to asking and telling. The first is must, the second is may, and the third is don't. Now, in no logic that I'm aware of is don't the antipode of must. There's one antipode of must, which is mustn't, which might mean the same thing as don't, practically, but it's not the same thing as don't logically. So Professor Spoo might say, don't usurp your role as commentator or moderator to become a commentator. Or he might say, you must not usurp your role as moderator to become a commentator. These are two different sentences. He's telling me two different things. On the first, the second one might entail the first, but it's not, doesn't work the other way around. It might just be that he says, don't do it because you'll put the audience to sleep after they've been listening to these fascinating people who are much more senior to you talk. Right? So we might recast the idea of don't here in their typology as mustn't, which would indicate maybe that don't ask, don't tell is imprecise. It's more like mustn't ask, don't tell. And that don't is not, don't might admit of a prudential sort of consideration, right? You might say, it's possible to do it, but the reasons weigh against doing it. That's different than saying you must not do it. There is a world of difference between a legal system that says, don't reveal client confidences, and a legal system that says, you must not reveal client confidences. And if you take don't to be equivalent to must, you miss the possibility that there's this difference in the world. Okay, so my diagnosis is that these two questions about modality and directionality are neglected in almost all norms scholarship. And the question is why? And I think the answer that I have has to do with how norm scholarship comes about. I think that the idea, and many of the people in this room sort of come to the discussion of norms through the tradition of law and economics, which does not really recognize much of a difference between don't and must. And so what that means is that if you have that prior commitment, you are, to a certain extent, putting on blinders to the possibility that there might be this difference in the world, right? If you think that it's possible that there could be a difference between don't and must, what you are saying is that there's something different than just not doing it that matters, that there's something different than the behavior that matters, and that normativity can't just be reverse engineered from the things that we do. I think and there's a lot in Chris's presentation that can be implicated in this, right? So the discussion of no exact copying in the chef's what did you call it? And I won't be able to do the French pronunciation. The staging, right? Right. He focuses on the exact part of it, but he might focus on the no part of it, right? Is it that if you do it, you will lose your credibility as a chef, or if you do it, you're just not going to be you're not going to be as good a chef as you were. But these are two different ways of formulating the no. So I propose that the neglect of issues of directionality and modality prevents scholars from capturing the empirical reality, and ultimately that's what it's about. It's about capturing the world that we live in. So I learned a lot from all three of these papers, and I hope you did too. And I hope that I haven't usurped past the point of propriety.